Okay, welcome. We will start this session. I'm Bart van der Sloot. I am the editor-in-chief of the European Data Protection Law Review, which is hosted by Lexion. Initiativa is there on behalf of the publisher. They are also organizing this event at CPDP. Okay, every year the journal has a special award ceremony. So we have 4 editions per year, and 1 edition is reserved for the young scholars. So we invite all students at master level or PhD students to submit articles based on their research, so this can be their master thesis or their PhD, to submit them. This year we got 25 submissions. From those, I personally selected the 10 best. Then me, Maya Lekamp, and Francisca Beun, who couldn't be here, were the jury of these 10 papers. If we were the direct colleagues of the authors of the paper, we abstained from voting, right? So, from these 10 papers, we selected the 5 best, which are published in the last edition of the European Data Protection Law Review. The 3 best papers are here to present their paper and to discuss with you. And the best paper will get an award, which is like the huge honor of receiving the award, and a year-long subscription of for EDPL, which broadens your intellectual scope, etc. Okay, so the order of things is that each of them will give a presentation. One of us, Mark Hall here, is replacing Francisca in order to comment. We will comment briefly or just say what a beautiful paper, etc. And then you can ask critical questions. And then the next is up. Is that clear? Okay, good. Adam has a very difficult last name. Panagiotopoulos.
That's right. Okay, thank you.
Was a master student at Edinburgh.
At University of Edinburgh, I did my LLM last year at the University of Edinburgh, and I'm going to present one of my papers, one essay actually, so it's not a dissertation.
Yeah. I think your slides are here.
This is Teresa's. So, hello everyone, my name is Autonomy-Preserving, and I will talk about genetic data, data protection, public interest, and communitarianism under the GDPR. Before starting, I would like to thank the Lexion publisher and the jury for their comments and for giving me the opportunity to be here with you today. So the title of my paper is The Genetic Information in Communities, a Triumph of Communitarianism over the Right to Data Protection under the GDPR. So this is a very long title, as you can see, not very practical for citation purposes, and it has very vague concepts. So how do we make sense of these concepts, and why do we need communitarianism to understand the GDPR, and how communitarianism actually fits under the GDPR? So let me give you some background information about this paper first. So as I told you before, this is the further development of one of my essays I wrote during my LLM last year at the University of Edinburgh, and my aim was to explore how we can reach a fair balance between public interest and data protection as an individual right. And at the beginning, I was thinking that if data sharing supports a collective goal, then data sharing should be facilitated and public interest should prevail. And this did make sense at that point, and then I realized that while I was working the first draft, that we have probably missed something. And what we have missed is that data protection is not only an individual right, but is also a social tenet, individual duty, and a communal and shared end. And to build my argument, I use a case of genetic data, which has communal and relational dimensions. So I use the case of genetic data, and I use communitarianism and the GDPR doing a comparison and to prove that these frameworks actually overlap. So this is my research question. This is what I just described. So the first part, I explained that genetic data has a communal dimension. And as you may know, genetic data is a special category of data under the GDPR. What you may not know is that the GDPR does not address this communal dimension. And to prove this communal dimension, I refer to three factors. So first, nature, then effect and context of processing genetic data. And regarding the nature of genetic data, I have identified three emerging properties: universality, relative uniqueness, and identifiability. So regarding the context of processing genetic data, I explained that an interest in having access to genetic data is not a matter of kinship only, but socially constructed groups such as researchers, partners, reproductive partners, society at large have also an interest in having access to genetic data. And regarding the effect of processing genetic data, I explained that the decisions and measures that are taken based on this data sharing for public interest has also implications for society and other data subjects. So the nature of genetic data, the effect and context of processing genetic data proves that genetic data has communal dimensions, and this actually connects everyone at an individual, social group, and biological level. And this is how we end up with an emerging wide genetic community. And in this community, which eventually embraces everyone, the next step is to consider whether this genetic community, and if we look at the bigger picture, we're talking about society, is autonomous in processing its own ends, even if these suppress individual rights. So in legal terms, what I want to ask you is whether individuals do or should bear a duty to share genetic data, even this suppresses their individual rights. So communitarians would say, yes, you have to share your genetic data if this is for the good of society, of the community, of the group, and so on and so forth. So I focus, because for communitarians the important feature is that community prevails over individual rights, individual preferences. So by default, the public interest is privileged. So I focus on responsive communitarianism to make it a bit more hard for me. So I worked on the work of Amitai Gioni and responsive communitarianism, and as you will see later, it's much closer to the GDPR than what you may think. So Gioni suggests a balanced approach between public interest and privacy, in his case, individual right. He says that we should, when we have to limit an individual right, such as privacy, then we should consider that this privacy actually hinders the public interest, the common good. These limitations should be minimal and should actually contribute to the common good. And in addition, he also proposed some safeguards, such as accountability, legal supervision. So what did you, and just a parenthesis here, I forgot that the common good in our case is the public interest. And the duty to share the genetic data is actually the limitation on our right to data protection when we're forced to share our data for public interest purposes. So what Gioni says and what I just described to you sounds very reasonable. But what Gioni has actually done is to suggest that public interest prevails. And this happens for two reasons. Because in his case, privacy, and in our case today, data protection and privacy are understood restrictively in terms of individual rights. And this means that when you have public interest and data protection as individual right, then by default, public interest will prevail. My second counter-argument to communitarianism refers to the disproportionate allocation of benefits and harms. So when we have data sharing for public interest, such as when we share genetic data for research, for the fight against terrorism, what we see is that the benefits of this data sharing are not distributed proportionally and fairly. Coming to harms now, and this is very crucial, and you can see more detail in my article where I present specific examples in cases where the trust and contribution to a communal end led to individual harms. And individual harms are not only the infringement of the right to data protection, but it's the right to privacy, to equality, to non-discrimination. Pause. Sorry for that. So this individual harm further leads to social harm, which is also very crucial. And when we talk about social harm, we mean the collective, unquantifiable, unforeseeable impact of this infringement, of this interference on the level of protection of fundamental rights within society, power balances, social structures. And the problem is, in this balancing, when we balance public interest against data protection, we tend not to take into consideration such harms, this typology, this taxonomy of harms, if there's such thing. Because as we just said, social harm is unpredictable. So coming to the GDPR section, I guess most of you wonder what communitarianism has to do with the GDPR. So the first part is that, as I told you already, data protection under the GDPR is restrictively understood in terms of individual rights. So it's an individual right, a fundamental one indeed, but this means, as we said, that public interest will prevail when it has to be balanced, be examined against a collective value. The second thing where we see communitarian values reflected in the GDPR is a public interest clause. And we see that public interest clause is a lawful ground for data processing, is a legal basis for limitations on the rights of data subjects, is a legal basis for limitations of the data protection principles such as storage limitation, purpose limitation. It's a mandate for national legislators to further derogate and to provide further exceptions from what the GDPR actually says, and is also a sectorial exception for public interest reasons, such as in the case of research. And of course, I do understand that public interest is necessary in a democratic society, but what the GDPR actually does is to entrust national legislators and data controllers, such as private companies, to specify what public interest means, and to also proceed to the balancing act, to balance public interest as they conceive it against data protection, which is prescribed a specific value in terms of individual rights. So it can be a genuine public interest, but there's also a danger that it can be an opportunistic public interest. It can be a socio-political public interest without taking into consideration that data protection is something bigger and there can be social harms in the future, in the long and short term. Not yet. So what I suggest is a different understanding of communitarianism, a duty-based approach to data protection. And what this means is that we should understand data protection and privacy in a tripartite way. It should be, of course, it's an individual right, it's a fundamental right, but it's also a social tenet, a social principle important for our democracy, for democratic governance. But what is more is a duty. It's a communal and shared end. And this means that we as society and as individuals, as members of the society, we have shared interests in controlling the uses of our personal data. And in this case, we don't talk anymore about genetic data. All the previous discussion was about genetic data, just to bring in this phase that genetic data has communal dimension. Now we're talking generally about personal data. So I used the previous one as a simulation. So what I'm actually suggesting is that communities, society, members of the community, individuals have shared interest in controlling the use of personal data, the implications of these uses, and have also shared ends in making sure that the uses of personal data, even if this happens for public interest purposes, will not have any adverse effect upon society, social structures, power balances. So how can this apply in our everyday life? So first of all, as individuals, we have to take care apparently of how to exercise the right to data protection. But in practice, and for data protection people, for public institutions, what they should consider is that we can actually apply this whenever we balance public interest against the right to data protection in different data protection exercises, such as data protection impact assessments. Or national legislators should also think about this communal dimension of the right to data protection when they legislate for restricting the right to data protection for purposes of public interest. And finally, what I would suggest is also that we should integrate in our everyday life, whenever we have data sharing for public interest, some control mechanism. And what we could do is to integrate like committees, advisory boards, which will be in charge for controlling that there's a genuine public interest, and this will not have any adverse effect in the future, in the long term, that we cannot actually anticipate, predict in advance. Thank you.
Okay, on behalf of the jury, Mark Hall will provide a few comments.
Yes, thank you very much. And after Bart has already introduced you, I can stick to Adam. That's easier, if you don't mind. And as Bart also pointed out, we will say some nice things about the papers. That's true, because normally in, for example, PhD supervision, you should always start with the negative critique and say what needs to be improved, what could be done better. But we are here at a Young Scholars Award, which means we have decided, or the jury has decided, that these papers are award-worthy. So I'm going to do it the other way around. I will first say what I liked very much about your paper, which I'm commenting on, and then give some ideas where one could also further develop the ideas that you presented. So one of the things that Adam does, which I think it has to be appreciated a lot, is he's taken a very theoretical concept of communitarianism and looked at whether or not we can prove that that is underlying a political text like the GDPR. But in order to illustrate it, he also took a specific category, genetic data, and applies his test to this category, which is already quite a lot to do in a short paper, I think. And you've done that very nicely. You scoped what we have to think about, and you presented that here very clearly. It is noteworthy, and that's the other reason why I appreciated reading your paper, that genetic data has received not only a specific definition, but also quite an extensive definition in the catalogue of Article 4. So there is a reason to give some attention to that. The reality is, there are a few experts, one of them is sitting in this room, who knows a lot about genetic data, but it's not exactly a hot, sexy topic around GDPR. There are certainly other things which have received more attention. So that's brave of you that you took that into account. And the last point that I would also like to highlight, because it's not that easy, your last slide does that in an even more condensed manner than in the paper. You come up with a proposal how to solve this potential tension between the two ideas of a community approach versus an individualistic approach in the GDPR. So congratulations to that, and I really think you've laid the seeds for things to grow even further in that field. And if I may, I'll give you some ideas, and maybe questions from the audience will add that. The first thought I had when I looked at the paper is, it reminds me of property. Everyone would agree property comes with obligations, okay? It's even written in most constitutions, there is a fundamental right to property, but you cannot do whatever you want with your property. And in a way, that's what you're hinting at. Genetic data is more than just what belongs to you, so there may be some obligation. Sometimes in the paper you mention there could be an interest to share genetic data because of the furthering of public health or maybe the erasure of illnesses. But an interest is probably not yet enough to turn it into an obligation. There I think one has to be a little bit sharper in thinking about how to do the balancing. Can one really argue that the public interest in having some genetic data available for research purposes or for comparative purposes is enough to actually take it away from the person, even without giving them a chance to say, no, I want to rest here? As a thought, and this goes a bit too far, but I was thinking of organ donors, Until now, we have difficulties in saying it would be good for people if everyone gives their heart when they die. But we are careful with that. Now, it's admittedly not the same to share data and maybe to give a part of your body, but it maybe goes in the same direction. And you could argue that because GDPR gives a specific protection to that data, maybe we have made a political decision to say it is something very, very intimate. And that's why maybe community has to step back, even if there may be a good purpose that could be done with this data. The other thing that I would reconsider if you continue in your future research career to work on these topics is there seems to be a negative take on the fact that the GDPR has put a focus on the individual. So you've shown both sides, but you in a way say, well, we missed something there. Now, I would say the political compromise of creating the GDPR already had to take two interests into consideration. One is the protection of the individual's fundamental rights perspective, and the other, don't forget, is the free flow of data. So already there is this balancing between these two interests in there. And if you then say, and we actually should also take in the perspective of society overall, how they can use data, maybe that is something that already has happened between the decision how much data do we allow to flow freely under the framework and how much data do we really give to the individual to say, I can decide what happens with it. And then helping community is a good argument, but with that we could also say, well, for statistical purposes, it would be great to have more data. Big data applications can lead to a positive effect, but remember, there are some issues in the GDPR, like Article 85, Article 89, that actually give indications on how to balance these differing interests. And finally, my thought on that is, well, it's a law, and the law will have to be applied in practice, and that means there will be case-by-case decisions. And the last suggestion you make with ethical committees might help mitigate the tension overall, but it's never excluded that even if an ethical committee says, yes, this data has to be shared, the hospital has the data and they can give it on, that an individual will go to court and the court will think about it, might even make a preliminary reference, and then the Court of Justice will have to say, no, Article 413 means full stop, you can decide not to share your data. There's one point that I would have really loved to hear more about. Maybe you can answer on that as a question. You mentioned combating terrorism as one argument for public interest. I have a slight allergy, in a way, whenever something happens at the moment, one of the arguments is it could help in the combat of terrorism. And I always question that twice. That's maybe because I come from the media law perspective, and content regulation in order to combat terrorism is kind of a dangerous issue. Maybe you could mention why that is used as an argument. I really didn't understand how genetic data could be especially helpful in that context. And admittedly, it's only a half sentence in your paper, so don't worry. And I would finish on saying, maybe it is good that you remind us that we not only have to think about the concrete provisions of the GDPR, but we have to think about the spirit. What's the underlying theory of the GDPR? And you know why? Because I think we are running into a problem on the EU level that we now have the GDPR, we have the police directive, we have all kinds of other data protection regimes, we have the PNR directive. And what we might need to do is, after 5 or 10 years of reflection, come to a result. What is the underlying value to data protection? And there, your approach with communitarianism can really help. So, having said that, thank you very much for your paper. Congratulations and an applause.
Thank you very much.
Maybe in light of time, it's good to get a few more questions and then respond to them. Yes, shall I give you the microphone? Yes, Michelle.
Thank you very much, Winfried Freil from Germany. I'd like to support completely your point, because in the discussions about data protection, I'm lacking this common good, this public interest point of view. I have the feeling it is missing all the time. And I would like to support your point with one decision of the German Constitutional Court from 1983, in which they practically invented the right for informational self-determination. They derived that right to informational self-determination from the right to personality. And they said everyone has to know everything about what other people know about them. But then they restricted this right to informational self-determination, and in a paragraph which is often overlooked in the public discussion. And I'd like to read out it because it completely supports your point. It's only one short paragraph, which is very, very fine formulated by the Constitutional Court. It says, the guarantee of this right to informational self-determination is not entirely unrestricted. Individuals have no right in the sense of absolute unrestricted control over their data. They are, after all, human persons who develop within the social community, communitarianism, and are dependent upon communication, which is another underlying point of view that supports your point. Information, even if related to individual persons, represents a reflection of societal reality that cannot be exclusively assigned solely to the parties affected. And then they say that the German constitution realizes that, and in the last sentence is, individuals must therefore in principle accept restrictions on their right to informational self-determination in the overriding general public interest.
Thank you. Okay, support for your argument. Keep it short if you can. Yeah.
Sure. Hi, I'm Dimitra Camarino from Queen Mary University. Thank you for your really interesting presentation. I wanted to ask, it's really interesting to me how always when we talk about the balance between data protection and other rights, we look at public interest. Of course, it's in the regulation, but did you, because your paper was specifically on genetic data, did you think about perhaps a balance between individual rights rather than, instead of data protection and public interest, data protection and right to health, for example? Because, sorry, okay, that's it. Okay, sorry, okay. Yes, I mean, that's my question, more or less.
Sorry, but yeah. No, okay. Then one more final question.
Dara Hallinan from Karlsruhe. I actually read your paper, and I completely missed this aspect of it. And it only occurred to me when you were presenting now. We talk constantly about the law, and nobody ever talks about how individuals should think about using their own rights. And actually, I think your paper is really, really strong in the direction of giving individuals an insight into how they might think about using their rights, rather than what should the law be and how should these things be balanced in courts, in a legislative fora, etc., etc. And it really didn't occur to me at all. But I think actually that's the real strength of your paper. I don't know, maybe if you agree or not, or whether, etc.
Okay, two people applauding you, so you don't have to comment on that. Keep it brief, please. Also, because we have other. Is that one or not?
Okay, thank you all of you for the comments, starting from the end with Dara. I really, really appreciate that. I think when I was writing that and I was talking about duty and right, I had in mind like being a parent, it's also a right, but it's also a duty, or having the right to vote. It's not only a right, it's also a duty. So thanks for bringing that in the surface and highlighting that. It's definitely what I also wanted to include in the paper. Perhaps I didn't do it in a very, very clear way, so thanks for flagging that. So regarding your question about balancing individual rights, so the first thing is, this is a very, very interesting approach, what you said, and I hadn't thought of it. So I'll just improvise. The common answer that a lawyer would give is like, you have fundamental rights, so it's fine, you'll just balance them, and sometimes there are some fundamental rights that you cannot restrict, but data protection is not one of those, so you can actually restrict. So it has to do with the fundamental right, which is under the Balancing Act. But what I want to say with this paper is that privacy and data protection together underlie the common good. So it's not like every other fundamental right. And this is the key idea, and I hope I will also answer to the other comments like that. The key idea of this article is that the pursuit of the common good, the chase of public interest, shouldn't allow the data sharing, processing data for public interest if this has adverse effects in the long term. And reflecting on what you said, and thank you so much for the census decision that you quoted, right? You talked about societal reality, and what we know is what we live. So I don't want to share my data, I don't want to have any duty to share under the GDPR for public interest reasons, just because I'm a bit afraid that in the future there will be adverse effects, that I cannot actually think of them now. I don't know how my data will be used in the future, and we may talk about genetic data, which is a bit of sensitive, it's a lot of sensitive, but it can be any kind of data. And I think this has also to do with the public interest, the common good. You asked about the fight against terrorism, and it literally takes 3 words in the paper, but I had in mind that what the European Union may want to do is to enhance the interoperability of databases, of genetic data. So we're not sure that behind this public interest there will not be another public interest. And the public interest can change easily. So going back to the census decision, the public interest is a very subjective notion, is socio-cultural dependent. I think this should be fine?
Yeah,
okay.
this is fine.
Okay, thanks. Thank you so much.
Thank you. Okay, on to, and you already mentioned the interoperability of databases, which is the perfect bridge for the second speaker, Teresa.
Should I put on my presentation?
It's up to you where you want.
No, I was at. Could you give me just this
The clicker.
Yeah. Thank you. I think it's already open, but okay.
Yes, you're right. It is.
And then you can just maximize.
Okay.
Okay. So my article was about the interoperability of EU databases and access to personal data by police authorities, national police authorities, under Article 20 of the Commission proposal. Now, the idea to build interoperable systems of EU databases for border control exists already since the early 2000s. But back then it was rejected due to the high costs, the technical issues, and because the security threat in the EU was not perceived as being very high. However, that changed with this so-called migration crisis and the terrorist attacks in Paris and Brussels in 2015-16. And shortly afterwards, a number of proposals to revise existing databases and to establish new ones were published by the EU Commission. And in December 2017, the proposal for the interoperability of EU databases was published by the Commission to have better access to information, to detect false identities, and to streamline law enforcement access to non-law enforcement databases. Now, the existing databases and the proposed ones are the Schengen Information System, which was recently revised, that consists of one regulation for border control, one for the return of illegally staying third country nationals, and one for police and judicial cooperation. The visa information system stores data of visa applicants, short visa applicants, and soon will also store information of persons that applied for long-term visas and residence permits. The Eurodac stores personal data of asylum seekers. The entry exit system was adopted in November 2017, and it basically stores all entries and exits of short-term visa holders and visa-exempted third country nationals that come to the EU. The European Travel Information and Authorization System is comparable to the American ESTA. Third country national will make an online application in order to ascertain whether he or she can travel to the EU. And then the European Criminal Records Information System for third country nationals and stateless persons is an addition to the existing ECRIS system for EU citizens, which will store data, criminal records on a centralized basis. So out of these systems, 4 have been adopted, 2 are currently being revised, and 3, the Schengen Information System, the Visa Information System, and the Eurodac are currently operable. Now, all of these systems have as a secondary purpose law enforcement access to data. They all store biometric data except for the ETIAS system. And yeah, so there are still other information systems that are currently operable, but I will not refer to them now. Now, what interoperability will do is basically connecting all these databases. I will not go into details of the systems, but maybe we can discuss afterwards. And the different components will store biometric and alphanumeric data from the underlying databases and create links where there's a suspicion of identity fraud. So there's 4 different components that establish the interoperability, which is the Common Identity Repository, the European Search Portal, and the Multiple Identity Detector and the Biometric Matching Service. So the data can be searched via the European Search Portal, which will be connected to the Common Identity Repository, which will store, so the Common Identity Repository will store certain data from the underlying databases and create an individual file for each person that is stored in these databases. The purpose of the Common Identity Repository are to facilitate the correct identification of third country nationals, to support the detection of false identities, and to contribute to simplifying and streamlining law enforcement access to non-law enforcement databases. Now, in my article, I focused on the Common Identity Repository, and especially Article 20 of the Interoperability proposals, because that article would permit member state police authorities to query the Common Identity Repository with biometric data in order to establish the identity of a person. If the query finds that data on that person is stored in the Common Identity Repository, the police authority or the police officer will have access to consult the data referred to in Article 18, which are basically the data that can also be found on a passport, plus some additional ones. However, for each set of data, so to each individual file that is stored in the Common Identity Repository, the Common Identity Repository shall also include a reference to the information system where the data initially belonged to. So the Visa Information System, Schengen Information System, Eurodac, and so on. So what happens is that the police officer could query the Common Identity Repository with the biometric data of that person and would not only receive information about that person and whether the identity is right that the person claimed to be, but also the reference number to the underlying databases where that person is stored. So a police officer could basically then know whether that person is stored in the Schengen Information System, which holds data of criminals, or in the Eurodac, or in both, and could from there then infer a suspicion of, for example, serious crime. Another possibility to access the Common Identity Repository for law enforcement purposes is the so-called two-step approach, which is similar to the first one I mentioned for the identity checks, where the police officer would get information in which system the data is stored and could then, in a second step, request full access to the underlying databases with prior authorization according to these databases. So the same happens as for the identity control, and the system, the interoperability system, can also be used for investigations. For example, if a police officer knows in which system data could be stored of several persons in order to investigate whether there has been a crime, a serious crime. Now, in the feasibility study that was carried out for the Common Identity Repository, identity checks were labeled as security and law enforcement purposes. Now, this has some implications on the applicable data protection framework, because where processing is carried out for immigration purposes, it will be the GDPR that applies to normal administrative processing. Whereas for the processing of the investigation, detection, prosecution of crime, so law enforcement purposes, it will be the law enforcement directive that will be applicable. So whenever there's a suspicion of serious crime, for example, let's say forgery of documents, which under the Europol regulation is a serious crime, a police officer could ask access to the databases and then process the personal data under the law enforcement directive, which would then have implications in terms of data subject rights. Because of course, police officers need to be able to process data more flexibly and to restrict data subject rights more easily. It also would have implications on the data minimization principle with regard to the principles under the GDPR or to subsequent processing. Because under the directive, the subsequent processing of personal data would be admissible when this processing is carried out by the same or by another controller for the investigation, prevention, detection, and prosecution of criminal offenses. So the general data protection concerns that arise with Article 20 of the interoperability proposals would be whether this access is actually necessary and proportionate, and whether it shouldn't be that a person would be first asked for his or her identity documents before processing biometric data, which are special categories of data. Another issue is the general trend to criminalize migration, which then leads to issues with the purpose limitation principle, where a law enforcement officer cannot really establish whether data has to be processed under the GDPR or under the law enforcement directive. So this blurred line between migration and security would then decide about the applicability of either directive or GDPR. Also, law enforcement access to these underlying databases, or at least to a certain amount of information, would be given without objective evidence of serious crime, as demanded by the Court of Justice. And of course, this could lead to racial profiling, not only of third country nationals or travelers, but also, of course, EU citizens, because they are also included in the databases. And lastly, there's of course a possibility to enlarge these databases or these interoperability components to, in the future, also include other types of data, for example, financial data or PNR data. So there's even more bigger issue with the purpose limitation principle. Thank you.
Okay, I, on behalf of the jury, will comment on your paper, but I will be brief because we're already running a bit behind and you took a bit more minutes to present. But I want to say this. As the editor-in-chief of the EDPL, I have to read many submissions, also which never make it to the journal. And it's seldom that I come across such a well-written article as yours. It's really well written, really well structured, and on a topic which I was not really aware of yet. So for all of you, I recommend you to read it. And also for the other young schoolers in the room, I recommend you to read it in order to learn how to well structure a paper, because it's really a pleasure to read. So that I want to say. The only advice I would give you, but I'm sure that this will come in your PhD project, but right now it's pretty descriptive. And which is good, because it really sets a good ground for the further discussion. But you should, because there's so many interesting points in here for further discussion and reflection. You do some things in the end, but still it remains still referring to case law in Germany or the Human Rights Court, etc. So I think you already have in mind many interesting discussion points. So I encourage you to pick on those, and feel free to also invest in your own reflection in there. Just feel free to do that. Okay, that were my comments, because I also want to give the floor for some questions, remarks, etc. Okay, another jury. Okay.
So thank you very much, Teresa, for this clear presentation. I have told the bar that actually interoperability is not my piece of cake, but now I see that there are questions that can arise. So I'm wondering, what is the underlying policy reason for choosing to have several databases rather than just one database? I can imagine that these databases have been set up as a bottom-up databases. But is there an idea on a policy level to merge those databases into one database? And what would that mean for a purpose limitation principle? Is it possible to have such a database that complies with purpose limitation? Thank you.
Okay, any other questions or remarks? No, you're all puzzled by this. Really intelligent. Yeah, I agree. Okay.
Okay, yeah, so in this article, I only focused on Article 20, which is, I think, the most problematic provision of this interoperability proposal. But of course, there's a lot of issues concerning the purpose limitation principle, because all these underlying databases were set up at different times for different purposes, and they had different legal bases. So while the Eurodac, for example, was for helping the Dublin regulation to identify asylum seekers and then send a person back to the first country of entry, the Schengen Information System is a law enforcement database. So now what has been done when establishing new databases or revising the old ones was to simply change the legal basis and say, okay, now we grant additionally law enforcement access, so we can also use these databases for law enforcement purposes because we might need these data. Because it's always useful to have these data because immigration can always be a security threat. So obviously this is a huge problem for the purpose limitation principle because in my opinion it is not possible to simply change the purposes of the databases and say, okay, we will just connect them and then we can use these different purposes that are not even really well defined and specific under the interoperability proposals. So the data can be used for so many purposes that are very wide that for me it's a very big issue.
Okay, no final questions? No, okay. Then another applause for Teresa, please. Then the floor to Emre,
Yeah.
also a difficult last name, which...
I am Emre B, you know.
Okay, there you go.
All right, after really two distinguished and young colleagues, dear friends and colleagues, after distinguished and young colleagues, I am the one, young in spirit. So, my topic is how to contest automated decisions and transparency implications. But I will go a little bit, I'll expand my presentation, and I also want to give a little bit of background of the PhD project, how this model that I present or that I try to define in the paper come to being. So, my PhD project, algorithmic transparency in European data protection regime and in the GDPR, this would, in practical terms, would come down to Article 22, which means that we understand transparency in terms of contestation. So the question is how to contest automated decisions. So my research questions, what that transparency would entail. Actually, that's what I'm going to talk about today. But my further reflections in the PhD would be whether this transparency model that I'm going to present is properly addressed or accommodated by the GDPR. And finally, I want to look at whether there are impediments from other legal frameworks to this transparency model, which comes to mind, firstly, which comes to mind, of course, IP protection or impediments from IP claims of the system owners. So, the question, we have a black box, how to approach the black box, what should be known. Okay, there's something, I guess, with the, yeah, black box. Okay, what should be known, how should it be asked? So we need a theoretical background. So my theoretical background is I made a mistake about, I guess, I don't know what, but I made a mistake. Anyway, so the point is that data-driven decision making or big data analytics is basically a type of techno-regulation in the sense that LESIC puts in 4 modalities. So coming from that, Article 22 actually regulates a regulatory technology. So it's in a way a meta rule, a meta type of norm which regulates a regulatory technology. So coming from that, from my point of view, contestation is not a problem of dignity, fairness, discrimination, because those relate with the substance of the law, but basically Article 22 or contestation is a due process problem. So coming from that, with my supervisor and colleague in a former paper, we just identified 3 types of due process harms. One is the normative impairment in this automated decision-making system. Norms are not ascertained, they are not easy to identify, so we cannot understand what norms are relied upon. Secondly, there is causative impairment, because we know that data analytics is the realm of blind correlations. So what we find as fact or input in this system does not conform to the known rules of cause and effect. Yeah. So, following from here, and well, finally, there is the moral impairment. As those systems get autonomous, decentralized, or dispersed, it's very difficult to identify the moral responsibility, the agency behind those decisions. So those are 3 due process harms. The idea is, first I want to know what goes wrong. Then if I know what goes wrong, I could decide what should be made transparent. So the point is that where do these systems fail to reveal those impairments? What goes wrong in a way? So I'm not going to go into detail because I have 10 minutes. It's not possible to explain this. But basically, you can see the first column is more conventional transparency problem, opacities. Those are more like the excess, visibility, or disclosure issues, you could say. And the second column, epistemological flows. And bias, this bias part is mostly taken from Nissenbau's, I think, 91 article, and it's still kind of good currency, I would say. And also, this is also quite much inspired, or I benefited a lot from Brand Mittelstadt and Van Otterlo. Their work has been inspiring. And coming to our contestation model, actually one of the inspiring names about this model or about this paper is among the audience, Ruben Binz. I have benefited a lot from his work, so it's so great, such a privilege seeing him here. So, okay, first, well, I am a lawyer, so I think like a lawyer. What do I need to scrutinize this system? Simple. I need to know what are the facts, what are the rules, and what is the decision, because I'm a lawyer. That's how we approach problems. So if we try to translate or convert this understanding as a rule-based model to automated decisions, the input part, the decisional cues, they are actually, we want to know what the system learns about the world, reality, or whatever phenomena under observation. So these input or decisional cues come as sometimes facts or evidence as we understand in the legal domain, but in the data analytics we have also inferences, predictions, assessments, which are subjective, not objective constructions as we understand in law. So then we have the norms. Yeah, exactly. For instance, thinking about a credit scoring system, the norm would be what score would suffice for a loan decision, what are the exceptions, what are the policy choices, what are the assumptions that the system takes as reference. So those systems do not have a prescription of such normative prescription. Those norms that I contemplate or anticipate are somehow implied and embedded, and they are not visible. So the effects, for the effects, we basically look at what is the impact of the decision, further impact of the decision, not only the immediate impact, but further impact. Again, giving an example from credit scoring, this credit score sometimes also determines the conditions of the loan, the interest rate, the time that you will pay back the loan. And the responsible actors, that's relatively easy, who made the decision. That's one thing I also need to know as well. So here, maybe most problematic part, the decisional cues part. Here the idea is, I'm so sorry about this, I don't know what goes wrong. The idea here about this, data is not a tool of insight. At the end, it is some factual, or it is a representation of the world. So system has many different types of representation of the world, reality, phenomena under observation. And here maybe what we try to do here is we are trying to profile the black box. So we are trying to reconstruct the decision, reverse engineer the decision, and so that it could be normatively intelligible, which will mean that certain factual input and the result could be verified, justified, or alternatively contested with reference to that rule. So a very simple example. Let's look at a traffic management system. actually going back, this shows that our model is very much related with the concept of procedural regularity. So in order to scrutinize those systems in a rule-based understanding, we need procedural regularity. This will actually, in a way, avoid retrospective rule making, because, you know, in law, we don't permit retrospective rule making. We only permit it in war and law. So it will either be rule of law or rule of war. But rule of law definitely is not keen on retrospective rule making. So reconstructed decision, as we have shown, based on facts or input, norms and effects, will provide the procedural regularity. So looking at a traffic congestion system, management system on smartphone data, very simply, for example, here we have three kind of input, or three kind of representations as to the phenomena under observation, which is traffic. So we just here, for example, identify three causes of congestion, like accident, rush hour, celebration events, or rain. I've changed it here to make it more colorful, maybe, I don't know. But each finding will result with an application of certain rule. The problem here is that things are not always as straightforward. For example, looking back to credit scoring, okay, what is the target variable in credit scoring? Credit worthiness. What does it mean? It means that do you have the capacity to pay back the loan? But sometimes maybe the system also working on the willingness to pay, which is not a part of credit worthiness, but sometimes the target variables or the factual findings could be structured knowingly or unknowingly in a way which would exceed the official definition of the problem, because credit worthiness is something determined, regulated by banking laws. So it has a definition. But while translating into an automated decision-making system, you could bring up different other purposes which are subtle, which are not visible, like willingness to pay or sense of responsibility of the loaner. So I'm going to make it in time. So my PhD project, okay, this is how we could operationalize this model. Actually, we have a three-tier of transparency. One is that the physical access, we all know visibility, access, disclosure, and sometimes some data visualization techniques, methods could be. Second one, which has kind of implied or anticipated support in the GDPR, especially with data protection, impact assessment, algorithmic scrutiny, because we know that those systems cannot be studied through full transparency or full openness. There are concerns about system integrity. There are concerns about IP claims. So where physical access fails or is not sufficient, we have to implement other forms and constructs of transparency. One is algorithmic scrutiny, and the other would be transparency by design. We could just design systems in certain way that their design choices will provide the necessary transparency. So coming to the last research question of my PhD project. Okay, 10 minutes and 8 seconds. So this is actually, it's that individual right. We need a collective, an understanding for collective enforcement of those rights. IP rights, I'm not going to go. There is contractual dimension, freedom of contract, right to knowledge, freedom of speech, and maybe machine integrity, but this is way too speculative. So this is, I think, more or less I want to say, and I'm so surprised that I could do it in 10 minutes, 30 seconds. Actually, I reversed this twice, one live and one in my mind, and I all failed, but this time it somehow worked.
You're better in real life, yeah.
Yeah,
Okay, on behalf of the jury, Maya, please, if you could, keep it short.
Yeah. I will try, because your paper raises many issues. With some of them I agree, with some of them I note. And I do hope that algorithms do not take decisions under such a time pressure as you were when you were presenting, because that would be a disaster in terms of accuracy of decision making. So I will, similarly as other editors, start with things that I like about your paper and that are positive and I think that contribute to the legal debate about this issue. One important issue is that you do develop a very clear theoretical framework expressed on a very high level of abstraction. And I think that theoretical framework is what is sometimes missing in the nitty-gritty details about what Article 22 is about, in particular its right to explanation. There are many papers out there that really go into the details of that article, and that is definitely necessary as a legal method. But you do develop this theoretical framework. Another thing that I think is positive, even though you did address it a little bit in your presentation today, is that you, in your paper, try to stay away from Article 22. And I know that data protection lawyers might not agree with that, but let me explain. So algorithmic decision making, as is also demonstrated by your example of GPS, they are not only based on the personal data. Many of them are based on the non-personal data that can equally have a significant or even legal effect on an individual. So if you have, for example, an autonomous vehicle driving a passenger and collecting data from the environment about the weather, about the tire grip, etc., and that vehicle causes an accident, that can, of course, have a significant, if not legal, effect on that person. There are also companies that might be affected by automated decision-making. Credit scoring is not only applicable to individuals, but also to startups, SMEs, who might or might not be awarded credit. So I'm happy that you do actually stay neutral on this point. However, this brings me to my questioning of your paper and of your presentation. And actually, I would like to throw at you certain challenges that I would like to answer in this discussion. You have spoken about the procedural regularity. So this is an argument which is made by Kroll and others in their seminal paper. But I'm not sure if this is really sufficient for the accuracy of the decision. The example that you use, coming back to my point on non-personal data, is an example using non-personal data, which in principle are not at all, or at least less biased than a personal data set. So if the temperature is 23 degrees, it is 23 degrees. You cannot bias the data, and hence the result can be more accurate. But procedural regularity, in my view, is not enough to reach an accurate decision on a personal data, which might, per definition, be biased. And that brings me to my second point, is that in your paper you make the argument, which everybody makes, so this is this mantra, that transparency can eliminate bias. To a certain extent, that is true, unless I have misunderstood your paper. I hope I didn't. To a certain extent, that is true, but that is true from the perspective of algorithm designers. But if you look at the individual, if the individual is not aware of that bias, no matter how much you open the algorithm, there will still be bias, and the individual will not enforce or contest this decision simply because of lack of awareness. And then the question of bias is also very much connected with the question of discrimination, which you treat as two separate concepts. And this is really where I'm really curious about how you explain this. Because you claim that those are two distinct concepts, but I would really like to see if you can give me a practical example, not a theoretical explanation of, you know, one bias outsetting other bias in the procedure. I understand it on a theoretical level, but give me one practical example where a bias in a data set, in a system, just let me finish, you can answer later, would not lead to discrimination. That has really been a challenge for me to understand. Okay, I have many other comments.
But you will finish.
But I will... do I need to finish or another one? Okay, I will finish and we can discuss a bit later. Thank you very much.
Thank you. Okay, either a question or a response.
Up to you. Well, it's okay. Let's start from the last one, bias and discrimination. Okay, bias is something, a technical issue. Discrimination is something to do with the substance of the law. At least if it is meaningful for us, it has to have a legal basis. And this is, as I said, discrimination relates with the legal domain. that the decision comes into being. So it will depend in what legal domain it operates. If it is recruitment, we will go look into labor laws. If it is health issue, we'll go into health regulations. If it is credit scoring, we'll go into credit scoring. So it cannot be a theoretical basis. I also include dignity.
I have asked for an example.
No, I will come to that, but this is more important for me.
For me not.
Okay, sure. This is the whole idea we're discussing. The point is that actually an example, this has been quite some time. I couldn't put an example there before because of word limits constraints. I already exceeded it, but I'm sure there is a reference there. I cannot remember right now where in that reference it explains with some examples. I couldn't put it there, and to be honest, I can't frame it right now because it has been like 3-4 months I wrote that part, and I can't really remember how that example was put there. I have an understanding, but it's not enough right now, so that's my mistake. Maybe I should have known my footnotes and everything in a better way, so I accept responsibility for that. Coming to procedural regularity, sure, procedural regularity is not sufficient. It's just one dimension. It's an important dimension of my model. My model is very abstract. That's true. Actually, many of the Article 22 issues that you raised are discussed in my third paper, which will come in Karen Young's edited volume, hopefully, soonly. And I go into detail also about those others data, using others data. Can I be subject to an automated decisions, not on my personal data, but on others' data, and those kind of Article 22 practicalities is coming in the third paper of the PhD. It is an abstract model, and I keep it abstract also for some reason. The point is that more you go into the details of machine learning, you find out one thing. Computer science, we are not computer scientists, actually we are reading the observers who know this issue, they write about it. But the point is that a computer science article or a machine learning article, those people in the engineering domain, they don't write for conceptual consistency. A machine learning or computer science paper is a tool which describes or teaches you something to do. So as long as they can make their point, they don't care about this conceptual or terminology consistency. So more you go into machine learning details, you get stuck with such confusions or in a way diverse terminologies. So that's why I am trying to keep it abstract, because for example, I am talking about data features, but now I'm asking to a guy, say, no, we don't use data features anymore. Now there are data lakes, everything is done on unsupervised learning. So at that point I understood that I shouldn't go into details of machine learning, but stick to my abstract model.
Okay.
And this is in a way, sorry.
Thank you. That point is clear. I want to ask Wojciech to come to the front. Because now is the time to give the award.
Oh, great.
Ta-da-da-dum. Okay. Do you want to announce it? Yes, thank you so much.
If I can. Wojciech Jarovsky, I'm the Deputy European Data Protection Supervisor, and that's my privilege today to give this award to the winner of this contest. But let me first say that I'm really very happy to be here and to take part in it. Also as an academic, I'm a professor in the University of Gdansk, member of the editorial board of EDPL, and I'm very happy that these articles, which I didn't read yet, I haven't read them yet, they are so diverse. They are from different perspectives, they are on different topics. Some of these topics may seem boring for you, but they are extremely important. I'm really very happy that we had the article about genetics. I'm really happy that you are sharing my love to all the things connected with interoperability of the large-scale databases, because it was hard to find somebody, even in my office, to prepare the materials when we had to go to Strasbourg to discuss with the members of the European Parliament about this topic and about the practicalities of that. And I'm really very happy as well that the last article that was presented here is a typical one in the legal informatics or legal cybernetics, which I'm actually teaching in my university. But I had no influence on the decision, and the decision was
can do this to,
Opening. And the Young Scholar Award of EDPL 2018 goes to Emre.
I can present my last chance to get a Young Scholar Award, so I am a bit embarrassed. With a white-bearded guy getting a Young Scholar Award is a bit bizarre. Actually, I applied to the award with the insistence of my supervisor, Miriel Hildebrand, because she said this is a good outlet. I could never do it on my own initiative, so I thank Miriel and I thank everybody. And as I said, this was my last chance to get a Young Scholar Award. So, well, I always thought I would reject if I received one, but I changed my mind. I think